Hi, everybody. My name is Deej Fukan, and I am a senior business manager at Events for Sure. And I'm super excited for today. I would like to begin by saying that this is one of our biggest webinars, and we have lawyers coming in from some of the finest companies in the world, and we have over 300 registrations for today. And we are super excited, and we have four amazing speakers with us on board today. The topic is managing contracts in a time of coronavirus. This is a very, very important subject. We did our surveys and figured out that this is something that people are looking for, and we created an amazing panel of speakers. And then, as you can see, that we have managed to have a wonderful session today. So we are super excited. If we can move to the next slide, I would like to explain you a little bit um, about what we are doing for the legal fraternity. Right. So we are very passionate about the legal industry, and we try and innovate every single day, especially with the coronavirus. So all our events were in-person events, but we have taken them online, and it has just got better for us. So we are doing online conferences, we are doing webinars, we are conducting meetings of buyers and vendors from across the world. We are doing online legal tech marketplace, legal tech demonstrations, online quizzes, interviews, updates, and much more. You'll be seeing a lot of events for sure, events in the coming days. So we will begin with the session now, managing contracts in a time of coronavirus. So we have five amazing speakers with us. Mr. Shaun Leong, he's the partner at Eversheds, Harry and Elias, Singapore. We have Rob Flaws, he's the partner head of TMT MENA CMS LLP at UAE. Plus, we have Francesco Falco. He's the head of compliance DWF Italy. He is on his way. He'll be joining us very soon. We have Mr. Ned Gannon. He is the president Brevia A. Defin Company, USA. And we also have Jarla's Law, Jan Kosvi. He's the managing director Malaysia and legal counsel Asia and regional compliance officer Asia at Siemens Logistics Singapore. So we will begin with Ned Gannon. Ned, can I request to please, let people know about yourself and your company, and and then we'll move to the next speakers.
Yeah, that sounds great. And thanks so much, and thanks so much everybody for joining today. So again, my name is Ned Gannon. I'm one of the co-founders and president of Ebrevia. Ebrevia essentially uses machine learning technology to analyze and extract data from contracts. So a little bit about my background. I'm a corporate attorney by training. I had done a lot of M&A work, primarily in the energy and infrastructure industries, and had just seen how inefficient and sometimes inaccurate contract review could be. So I got together with a good friend from law school and a machine learning engineer, and we ended up partnering with Columbia University's Data Sciences Institute to leverage some of their machine learning expertise and apply it to this legal application. So today we work with corporations, law firms, audit consulting firms, financial institutions, commercial real estate firms, and legal process outsourcers around a whole host of different contract analysis and review applications. And I'm happy to say in December of 2018, we were acquired by Donnelley Financial Solutions, or DFIN, which provides a whole host of different types of products for risk and compliance and legal. So looking forward to the webinar today.
Good afternoon, everyone. My name is Jaroslav. I'm responsible for both, for double role in my organization. So on the one side, I'm leading our business in Malaysia. So I'm responsible for all of the business activities. And on the second side, I'm also leading our legal department team across Asia. So that's why I would say when I saw also the title, that it will be very exciting to talk with you and share the webinar, because that's where I can also share the experience, both looking from both business and legal perspective, how we do it in the multinational corporation, and I work for Siemens. Thanks a lot, and looking forward to having a fruitful discussion.
Ned, I'll ask you for your perspective first. How has the contract management community been faring? I mean, I need your perspective on, how are they be faring, and what can we learn from the progress today?
Yeah, so I'd say there's a few pretty consistent themes that we've been seeing, and obviously it's a still fairly new and developing situation. But I think one thing that's been interesting is to see a bit of a shift in terms of the provisions that folks are focused on, particularly our corporate clients. But in any case, we're seeing a lot of interest and termination provisions from a lease perspective as companies want to get a sense for their options, particularly in this work from home environment. Of course, people are also looking at employment, severance provisions, termination provisions there as well. And then obviously the big thing as some companies start to move into bankruptcy or restructuring type capacity, loan commitments are something that folks are focused on too. So that's just one general theme, seeing a bit of a shift again in what people are interested in. I'd say another thing that has kind of struck me, which I didn't anticipate, is that we are seeing some regulatory driven use cases that haven't been particularly impacted by COVID. So if you look at things like the LIBOR transition, most of our clients that have been focused on that are still moving full steam ahead with the pressure of that, that transition in 2021. So I think that's been interesting. And then just thinking a little bit about moving forward, I would expect, we'll probably start to see on our radar screen more interest around post-merger contract migration work, particularly as companies are forced to consolidate, as a result of the pandemic. So I'd say kind of moving forward, that and restructuring are things we'll be seeing quite a bit of.
Great, great. Thank you for the perspective. Jaroslaw, can I get your perspective on this?
Yeah, sure. Thanks. First of all, like managing the contract in this time of the coronavirus now, it's I would say our global problem, because we are the multinational corporation. Obviously, we are facing issues in each and every country, and all of them are distinctive for their respective jurisdiction. So there is obviously no one size fits all as the solution that would basically serve us in each and every country. But what we see as the harmonized approach is that we see that each and every of our CEOs becomes kind of even the expert in the force majeure clauses. I have never seen so much attention and excitement whenever we do any type of the project reporting in our organization about what about the force majeure clause, what about frustration of the contracts. Everyone is becoming the expert in that, and it only shows where the attention comes. So basically, attention so far was that contract management as such used to be traditionally considered as the cost center. Typical cost center, no one wants to invest any money. Basically, the less money you spend the better, because how you want to save the cost on the projects. Obviously, right now, when we look at the current situation, how vital the role of the contract management becomes and the professionals working on the contract claim management, it seems that we are more becoming the profit center than the cost center. So that's, I would say, looking from the business perspective and cost calculation perspective, that's, I would say, visible shift, and also the attention that has been given. Because right now, I think that also on the business side, people that have no, I would say, legal expertise, I would say, experience, they came to conclusion that obviously without the proper records, even if you are absolutely in the stronger, I would say, moral position, you are going to lose the case. So ultimately, the contract management becomes more and more important, also in the big corporations, where the role and also to keep the good records also are becoming of the highest value. Because what seemed to be working as the long-term partnership for so many years, in terms of the pandemic challenges, it's not always the case. So I would see that I would say as the general remark, that would be the situation. But obviously, on the case-by-case basis, on the country level, when we see a number of the regulatory changes, we see the different type of the also future strategies, how we can also address the contracts that could be already foreseen, because pandemic is pending, but it can be already foreseen. So what about signing the contract here and now, when we know that these travel restrictions are going to last longer? Yeah, so that's also a matter how you can also address that for the future, for the situations where you cannot really benefit from some of the traditional clauses that you would normally relate to. So that's, I would say, the general feedback from I would say my end.
What do you think is the extent of disruption and the scale of difficulty?
Sure, happy to comment on that. And I thought I heard a little bit from Shaun there as well. So yeah, I mean, I think obviously we've seen it impact a lot of different industries, a lot of different geographies. From our perspective, I'd say some of the industries that have been hit maybe the hardest and are as a result looking at their contracts in that context include the airlines, casinos and gambling, auto parts, oil and gas. In terms of the scale of the difficulty, I think it's interesting to, it can be viewed through a number of different lenses. So obviously you have the lens of the corporate or the borrower in many situations. But then we're also seeing financial institutions heavily using the software to go through their loan portfolios, understand a lot of the credit risk there, even if it's some of their borrowers aren't in a restructuring situation yet. They want to get a sense for how things are going, seeing the loan covenants, et cetera. And then of course, dovetailing on that, you have the service providers like the law firms and audit consulting firms that could be working on either side of that equation on behalf of the borrowers or on behalf of the financial institutions. So, I mean, I'd say in terms of disruption, it's significant. In terms of scale, it's significant as well. But I think we have to, again, kind of see how events continue to develop, and that will hopefully, start to make the path forward a little clearer.
Can just fully agree with Ned. Like, this is obviously visible, especially I come from aviation business. When most of our customers, airlines, airports, are either in the lockdown or they are facing huge challenges, I would say, to keep it very gentle. But obviously, at the same time, there's also a number of the businesses that have not been disrupted. Quite the opposite. They have been also benefiting from what is happening now, such as e-commerce business. Because, for instance, in the Siemens Logistics, we are provider of the sorting systems for all of the parcels coming to Singapore, and we can see based on in our systems that, for instance, there's a huge peak. Almost the system is operating in the full size just because of the number of the e-commerce and the parcels that have been ordered online, just because of us being trapped in the homes. Yeah. So as you see, there's always, I would say, someone is always benefiting from the situation, but we also see that the extent of disruption is depending on a country by country basis. So China obviously have been suffering in February, but right now we are back in a good business there. There's new projects coming. Supply chain management has been again accelerated. So I would say in some of the countries we are facing, I would say, smaller or bigger problems, but it's all combined bodies. So even if China, for instance, business is growing, but we are still having travel restrictions in our cross-border business, then still we are going to be in the ultimate situation still affected, which is also proving a number of our projects when we had to mobilize our international teams, and just because of travel restriction we couldn't perform that properly. So I would say that's also the challenge for us, how to see the big picture, not just one jurisdiction or our business, because that's all combined bodies right now.
Ned, again for you, the question is, companies are still automating a lot of contracts, and what does it lack at the moment? What is your perspective on that?
Yeah, so I think there's actually a distinction here when I think about it anyway, and it's kind of between the automation on the front end. So that's in the negotiating phase of the contracts, the drafting phase of the contracts, and then you have the negotiation, the automation post-execution, which is more of the contract analytics related to analyzing and extracting data from the contracts so it can be tracked over time. And it's really that second part that eBrevia plays in. There's a host of other really good companies that are in the first part as well. But I think when you think about automation generally, there's a whole kind of spectrum, and what we've seen to date is, for the most part, AI isn't replacing the lawyer or other human reviewer, really acting as a tool to supplement what they're doing, helping them do their jobs more accurately and efficiently. And when you think about that on a spectrum, you have, let's say on one end of the spectrum, a very simple tool like a keyword search. And then on the other end, where I don't think any tools are today, you'd have a system that can digest contractual language and provide legal advice without human intervention and 100% accuracy. And obviously we're not there either. So I think, you know, the standard of the industry is somewhere in between. We're certainly moving, advancing down the spectrum, eBrevia and some of the other players out there. And you're starting to see some of these tools usurp more and more of the human tasks, moving up the value chain. And I think that'll just continue into the future. And then I think the other big piece of it is attorneys and sophisticated business users also have to get more comfortable relying on the tools. And you'll see it, as I said, continue to take a greater share of the workload.
Thanks everyone for having me here. So my name is Shaun Leong. I'm based in Singapore, but my practice is very much global. So my area of focus is on advising on cross-border strategy and on commercial disputes. I served as a magistrate and registrar of the Supreme Court of Singapore for about 5 years prior to practicing in the Magic Circle. And I'm currently sitting as an arbitrator on several international arbitration institutions, those based in China, in Bangalore, India, as well as in places like Thailand and in Central Asia, Tashkent. So I'm very happy to be here. Just sharing very quickly some views from my end. Obviously, we have a diverse range of speakers here today, and it's very helpful to gain perspectives and insights from different sectors and different experiences. But what I've seen really is that there's an immense amount of pressure on the contracts that weren't drafted by you, that were actually drafted by your predecessors. So because of the pandemic, and as Ned and Jen has said, frustration, force majeure doctrine, there's a greater incidence of force majeure cases now. But really, the essential element of force majeure is that it all depends on the language of the clause. So every transaction, every multi-document situation, you have a little bit of differences in the force majeure provisions. They are never exactly the same, right? So the precise rights and obligations really boils down to the language that someone else have used in the contract. And here's the thing, you didn't draft the contract, but now you're being made responsible to manage the situation, right? And there's a lot of issues that you need to have regards, because, for example, what if you're not actually looking at a force majeure provision? What if you are actually in essence looking at a hardship clause? What if you are in essence looking at a variation agreement, to say that, look, I may not have the rights to terminate the contract, but can we at least vary the contract, right? And what if you do not have a force majeure provision? So I'm getting a lot of disputes and cases around the situations where there's inadequacy or inadequate provision in force majeure provisions, in which case you have to rely on the general law. Now, just to have a quick few minutes on this, in terms of relying on the general law, whether is it American law, the civil law doctrines of Vietnam, or common law doctrine of England and Wales or Singapore, generally speaking, the threshold is very high. Okay, you need to prove that that it's almost impossible to perform the contractual obligations, and you need to demonstrate that the impossibility or the near impossibility is to a material extent caused by COVID, caused by the pandemic, right? So I'm happy to share more, but I think it's about time to share the microphone with my other speakers now. But that's the gist of what we are seeing from the legal practice, that there's tremendous amount of pressure on a force majeure language that you didn't have a hand in drafting. Thank you.
Maybe I'll just let me refer to what Shaun said, because definitely I must agree with that, because we are running the business across Asia. So we can see what I said in the beginning, that one size does not fit all of the patterns there. And obviously we are facing different challenges on different projects when we have different applicable law, different force majeure clauses, different frustration clauses, etc. And we have even different regulatory system, because for instance, Singapore has implemented separate COVID-19 temporary measures act just to address the construction and supply contracts in Singapore just to allow for the potential defense right in the event that you have no force majeure clause to rely upon, for instance. That's why I would say it is, but not just looking from the legal perspective, but taking also a bit business perspective here. It's also about strategical, I would say, decisions that must be made on a case-by-case basis. How do we want to proceed? Because obviously, in the standard force majeure clauses, you are going to have a schedule relief. But if you look from the global perspective, that's not sufficient for us, because no one wants to have just schedule relief without having the additional payments being covered for the extension of the project duration. So that's also the thing that we are normally looking at, how we can negotiate and how, irrespective of the contractual wording, still find a business, I would say, solid agreement with our counterparties, either on the customer side, on our supplier side, because obviously we talk about force majeure working in both directions, that we are squeezed by our suppliers and we are squeezed by our customer. You are in the sandwich scenario, somewhere in between, trying to offset and find a good way. So I would say, although I would love to have the automated solution that's saying, oh, that's my brilliant solution, I present it to each and every of my management in each and every of my country, and that's what we are going to do. But unfortunately, that's, I would say, fairy-tale word still, because we have different customers, different legal cultures, different provisions that you can rely. For instance, in China, what I like about, for instance, the contract law there is that it clearly states that in the event that you cannot hide behind force majeure event to hide your own delay. So if the delay has been already occurred prior to beginning of the force majeure event, then you cannot benefit from the force majeure event to hide your own defaults before. And it's clear wording from the Chinese contract law that prevents you from benefiting from that, which is also very good, because we also see, I would say, increased number of the alleged force majeure cases. Right now, everything is force majeure. It's like, I cannot go there, force majeure, but everyone are forgetting that the standard of the reasonable mitigation of your losses, or the number of the causation link that must be proved, is still very high, and you cannot just just refer to the force majeure to basically leave yourself from the obligation. So that's also, I would say, very interesting time, and I see coming from what's the scale of difficulty, I see this workload coming to the contract management tiers is higher and higher. So I would say that's, one of the busiest time for our professionals working just on our contract management, just to make sure that we keep the records, and we also keep the good, I would say, customized strategy to also address what are the customer needs, what are suppliers needs, and what are our also financial objectives for the project. So that's, I would say, also the challenge where the human factor is very important. But I would be very interested to hear what Ned has about that, because you are trying to really help us from the, I would say, a legal tool perspective to optimize that. So I'm very curious, what would be then your advice to my industry, how we can now say maybe facilitate to the progress of our discussion with the customers? What can we do better then?
Yeah, sure. Thank you, and happy to comment on that. And I think both you and Shaun, raised some really interesting points there, and certainly some themes that we're seeing with respect to some of our other customers as well. But I would say, it's interesting. So Shaun had raised the point of really looking at the force majeure language and how that can vary by contract and its impacts generally on the situation. And then I think your point is a great one too, in that there's often outside factors, whether it's the legal, the law of the jurisdiction that you're operating in, or other things that might influence the analysis as well. And I'd say, really where the tools, AI tools like eBrevia can come into play is primarily helping to address Shaun's issue, which is a key part of it, and provide the data for the attorneys to then do the analysis, taking into account the jurisdiction and other outside factors. I know what we've seen with a lot of our customers is, a lot of these things are happening so quickly that doing a manual review of all the contracts can be challenging. So the AI is able to come in, easily identify and extract those force majeure provisions, help to categorize those, which can accelerate the analysis. But just to underscore again that this is not, typically a solution that's just used, it's not a pure software solution. You really do need that human expertise as well. We had actually done a white paper in conjunction with a couple of our clients, Baker Hostetler, which is a national law firm in the US, and then Quizlex, which is a global legal process outsourcer. And they actually took the tool and went through a wide variety of contracts over the last 20 years, looking at force majeure provisions. And these were across a variety of industries: entertainment, financial, healthcare, utilities, supply chain services, et cetera. And they actually came up with some kind of interesting points, and I'll share a few of those. So for example, they found that about 57% of the force majeure clauses contained a specific reference to government action, which would certainly be triggered by a lot of these shutdowns and quarantines, et cetera. Interestingly, only 18% of the clauses they looked at had a pandemic mentioned specifically. But then a significant majority, I think about 75% or so, and these are primarily US contracts, but did have this act of God concept, which can serve as a catch-all for a wide variety of different circumstances. But then again, when you're looking at that kind of that broad catch-all, that makes that the jurisdiction or the outside factors even more important. So these can, as I said, it varies by jurisdiction, it varies by company, and what the negotiating power is between them at the time the contract is signed. But it is a situation we're seeing a lot where people are really wanting to dig into those force majeure provisions, both to protect themselves and then to understand their options as well.
Robert, if you can also give your perspective, and just let us know about yourself a little bit, and then give your perspective.
Okay, well, I think Ned sort of segued quite nicely into a big area that I get involved with. So I work predominantly on the technology contract side of things across the Middle East. And Ned's point about government actions and being, a key component of force majeure in terms of the analysis that his company has done is a very interesting one. Because as you can imagine, there are a lot of government action style provisions in IT contracts in the Middle East that have raised similar issues that we're dealing with now in terms of how you manage contracts, particularly in the IT space. So in the Middle East in particular, there are a lot of government-related IT contracts for the large, sort of, as we call, giga projects out here. So, the big projects that everybody's read about in places like Saudi Arabia, the large-scale e-government programs across the Middle East here. So I work on sort of both sides of things with clients in the IT space, very similar to Jaroslav, and also with some of the government contractors. So as you can imagine, there is a very large debate at the moment as to how we continue to progress these projects and what the costs and issues around milestones, KPIs, etc. are, given the current situation. And as I say, it's not an unusual debate out here because government action clauses have been used quite regularly to change contracts quite dramatically. And we've had to pick up dispute issues, which I'm sure, Shaun has dealt with before as well, where contracts have changed quite drastically at very, very, very short notice. So I think our role at the moment as legal professionals in this space is really to think about how best to manage the risk on all sides. And what we've been looking to try and do is sort of these sort of emergency work order style structures where you're effectively trying to discuss and agree a significant change to the original document whilst also managing sort of costs and liability. So I think that's a real challenge, and I think some of the tools that Ned is proposing as part of his outsourced business are actually very, very useful, because a lot of people are struggling with the size of these contracts to really understand the scope and length and level of the provisions that allow you to do this. And a lot of time is being wasted really analysing the depth of the force majeure clause and what it means. And in a lot of cases, unfortunately, and this is the point Shaun very nicely touched on, you're dealing with contracts that have been done by your predecessor or somebody else within the organisation that you're now acting for, where the force majeure provisions have been very poorly drafted. And I like Ned's point about the pandemic clause. I think that would be now a solid piece in drafting force majeure going forward. So it's really now about how to manage a solution where all parties can move forward and actually get these projects going again without being stuck in the issue of, is this understand and appreciate, of course, that, you know, really this is a force majeure event. But from the IT side of things, you know, the supplier has committed resource, expertise and material for only for a set period of time, and their P&L on these contracts is based on a specific delivery time frame. Whereas for the customer, you know, the anticipated savings, the continuous improvement, the KPI around the service is also very, very time based. So it's really now all about how we manage this to ensure that those deadlines, those periods can be done as efficiently as possible, and that there isn't a huge loss on both sides, either from the supplier side in terms of what they've committed and the expected P&L, and the customer side on, you know, the expected anticipated savings. So it's really almost like, you know, the emergency work orders, the relief work orders, whatever you'd like to call them, are now being used to effectively rebalance a lot of these contracts. And I think automation has a big role to play in this, because, you know, when you're wasting time trying to work out where the clause is, what the clause is doing, when you've got 50, 60 of these with a particular supplier and customer, then it is a real mess. So it's been really interesting to hear Ned's point about, you know, the importance of using technology to search these contracts for key provisions. And then Yaroslav's point about, you know, from a supplier perspective, how you can manage a strategy around this once you've done that. So yeah, I think those have been really interesting points. But as I say, in the Middle East, you know, the issue of government action has long been something that we've had concerns about and warned our suppliers of the risks about. And that's really now more pertinent than ever, given the current situation, because, you know, projects can just be stopped, regardless of whether there's a pandemic piece in the force majeure, because of what governments out here are doing. But that's always been a risk here, and continues to be a risk going forward with the instability in the region. So it's a very interesting and challenging time, particularly in the tech space.
I would be very interested, Shaun and Robert, like just one question to you and your basically also your experience, because, you know, traditional, as we said, and as we are all also on the same page, the schedule relief would be something that normally I would say with certain degree we can always achieve. Yeah, either we refer to force majeure, to act of God, whatever hardship clause we like to apply. But what about the cost relief? What's your experience in terms of the successfully managing also the cost compensation for all of this lost time that our people are stuck and cannot proceed with the so obviously you cannot to traditional, you will just refer to force majeure clause. You have no cost relief normally, at least in most of the jurisdictions. So question, how do you address the payment aspects?
Yeah, it's a really, really pertinent point on the supplier side, because it's something we've really tried to push to our suppliers, this idea of a double relief. So obviously customers push very hard for, obviously, you know, service level relief, milestone payments, delay payments, liquidated damages, whatever you want to call it. But at the same time, particularly on public sector contracts out here, a delay by the customer can actually cause the supplier some very, very serious cost issues, because, you know, particularly in situations where you've got government contracts where the customer is not providing the relevant information to enable the supplier to push forward, that inevitably causes a delay. And obviously you get a relief event in terms of the fact that it's not a supplier fault, but the fact is that you're not able to drive the delivery forward in the manner that you want to. And as you say, you've committed costs and you've committed resource, which means you can't move that team onto a new project. You can't step that team across into something else that you're trying to do. You're having to pay for resource to be deployed in a specific region for longer than you budgeted for in the P&L of the actual agreement. So I think one of those things is that what we've tried to do whenever we've acted for a supplier is try to sort of time-based delivery points in there as well, and make it clear that percentage cost of a particular milestone can be increased, you know, dependent on the actual delay. So try and time lock provisions in to make sure that customers aren't delaying things like acceptance certificates. They aren't delaying, you know, their feedback to enable a particular deliverable to be created. And I think in the situations where we've managed to get that in, we've drafted it widely enough to make sure that, you know, from a relief event perspective, that enables us to have that discussion. Now, the problem is, of course, is that, you know, it's not a one-way thing here. Customers themselves are now suffering as well, because obviously they're not getting the delivery at the time that they want, and it's not the supplier's fault and it's not the customer's fault. So it's a case of it really has to be a balance between, you know, the unamortized setup costs and the cost to the customer, and a real discussion about how that liability is equally portioned out, because both parties are losing here. So I think that has really formed one of the key parts of these sort of relief change orders, relief work orders, as to how you balance that loss. And it's really all about having the relationship with the customer to say that, you know, there's both parties losing here. Don't think that we are, you know, just getting paid and we still get paid at the end of this, and all right, there's been a delay of a few months, but we're still getting the, you know, the profit line on the top. That's absolutely not the case. And the reason we've put provisions in this contract to state otherwise is that, you know, this project for us is time-based. We need to move these teams around. We only have specific resource for a specific period of time. We can commit to this contract. So I think if you're fortunate enough to have the provisions in the contract that allows for, you know, this kind of reverse delay, this ability to increase milestone-based costs on the basis of a delay caused by the customer, or in the event of a relief event, then you can have a very serious conversation. It's just, it then becomes a real relationship issue, and also how receptive the customer is to the possibility that, you know, it's not all, you know, a gain for them. You really need to try and make it a win-win. And that means a bit of give and take in these relief work orders, but it's a very, very good point to raise, because I think it's probably, in all honesty, it's the key point. You know, from a supplier perspective, you are trying to guard your top line on this, and if it becomes a situation where the project is literally a zero gain, a zero profit, then, you know, it's something we're having to advise the business to simply think about whether we continue, because if you're going to lose, you know, if you're going to lose margin on this to the point where it's literally a zero delivery, then it might be a case of, you know, walking away from this and looking elsewhere. And I think that really has to be communicated to the customer.
Hmm.
I think for Southeast Asia, in the ASEAN region, you are really beginning to see two different approaches to managing the cost component of what you rightly mentioned, Jen, which is a significant point. I think on one hand, there's the developers, the contractors, and the subcontractors who know that they have project deadlines to meet, and those project deadlines were contracted for and agreed upon before the pandemic. And now with the pandemic, you know, they realize that actually, you know what, no matter where the cost lies, we're going to suffer greater amount of loss if we start litigation, if we start suing each other, and the project doesn't get finished. Because it's not just about the contractors and the subcontractors and the developers. It's about people who bought on the project, who are waiting for us to complete the project. So if we start litigation amongst each other, you're gonna be sure that you're gonna face indemnification suits from people who have bought on the projects, right? So you begin to see some kind of a frantic chase for allocation of risk and allocation of cost. And you see two different patterns. The first pattern is the mediatory approach, where they sit down with all the stakeholders and say, look, someone's got to bear the loss, someone's going to bear the cost. We're not going to say anyone should take 100% of the cost. But in order for the project to carry on, I think that cost component has to be spread out right across the board. And for some jurisdictions in Asia, like in Singapore, liquidated damages have been frozen for the time being. And this actually facilitates the soft approach where people get to mediate. And you still see the hard approach, which is people sue and litigate, not necessarily to win, but actually to put pressure on the opponent. And amongst the soft and the hard litigious approach, you actually see a matrix of very interesting tactical behaviors taking place on a cross-jurisdictional scale. And this is where I think Ned and his platform would be aware of. You see, a lot of contracts are not just one-dimensional. You can have a joint venture agreement, you can have a shareholder agreement, you can have a facility agreement, a side letter, and a purported master document. And can you imagine, out of 5 or 6 contracts, each of them point to a different direction. So I can litigate before the courts in New York, you know, the first Southern District. I can choose to arbitrate in Singapore. I can choose to arbitrate in Hong Kong. And a 4th contract says is governed by Vietnam laws. And a 5th contract says is governed by the laws of England and Wales. And you begin to have a dynamic situation where essentially you get to choose where to fight your dispute. This gives rise to the phenomenon in Asia where a lot of parties are fighting over where to fight your disputes as a tactic. So for example, I give you a simple example. I can initiate arbitration in Singapore. At the same time, I will launch a Mareva injunction to freeze our assets in Hong Kong. Right? And at the same time, I'm beginning to threaten formal legal action in a Southeast Asian country. These 3 things can take place concurrently at the same time, right? All in a matter of putting pressure and adding on to the tactical game plan in the negotiating table to say, look, you know, if you take 20% of the cost, you know, I will stop all action. So you're beginning to see that situation in ASEAN, in the ASEAN region where, you know, nobody is really very sure where exactly to fight your dispute, but we are quite sure that the tactics and the pressure that's placed with the tactical applications in different jurisdictions can enforce and reinforce your bargaining power, you know, on the negotiating table. I mean, that's the trend that we see now in the ASEAN region.
I'll just make a kind of quick follow-up comment on that, because I think that's right. You know, there is often a lot of interplay between various different agreements, and they can point in different directions. And one of the challenges is teasing out what's controlling or what some of the options are. That was something one of our customers in particular had been confronting quite a bit, and made some product development requests. So we built in a grouping mechanism which kind of pulls the agreements together and helps present the information in a little bit more easily digestible format. But that is a theme we see pretty consistently. So it's interesting that you're certainly encountering it as well, Shaun.
Right. So we've started getting questions, very, very interesting question, but we'll ask you at the end of the webinar. So let's move to the next point, you know, the coronavirus outbreak and the supply chain risk. Guys, if you can just give your perspective on that. Ned, we can start with you.
Yeah, I don't really have much more to add here, other than what I had shared on force majeure generally. So I'll defer to the other panelists on this one.
Right, Jaroslav, can we have a small perspective from your side?
Yeah, sure. Yes, especially from our like multinational corporation, that's I would say the bread and butter of our business. Yeah, how to manage our supply chain risk in the global perspective. So obviously that's, I would say, the huge challenge. Thanks God, not bestowed on legal shoulders, but on our supply chain managers. So I don't need to deal with that, which I'm very happy, because honestly speaking, that's a huge challenge. So obviously we can only talk about diversification of your supply chain, yeah, and basically rely upon your business partners from not on the single source. So that's basically the most simple response to that difficult question, yeah. But it's never so simple, because it's what we face in one of the projects when we have 2 factories to choose from. One is in Hungary, second one is in China. China has been affected in February. Then we moved to Hungary, and then in March it was Hungary that was affected. So we moved back to China. So you see, like, even if you try to diversify looking from different continents, still you are going to be affected sooner or later, especially if you talk about global pandemic. Yeah, here's the global consequences. So I would say that what is important here, and what we are facing, maybe also coming back to the previous hour discussions, and maybe also following up of what Robert and Shaun has been commenting, is what we are facing in our business is always discussion about acceleration costs, because ultimately we talk about schedule relief, we talk about, you know, KPIs put both on the customer and on the contractor side, and still we talk about this enormous pressure that has been given by the customers, or by to still accelerate. They like the words to accelerate. So obviously that's the room what we are using as the potential vehicle also to find, I would say, win-win-win. So basically move from the lose-lose situation. If you go, I would say, in the hardcore scenario, when we just claim schedule relief, they are going to have 6 months delay, but it's not satisfactory for none of the customer to suffer the delay. So obviously the room for the potential creating win-win scenario based on our experience in Asia is to create accelerated schedule based on the acceleration of the cost. So where we can already find some, I would say, win component for the customer when he can maybe offset some of the part of the delays on his side, when we can also recover maybe some of the costs on our end by not hiding the cost, but obviously by, I would say, putting them under the different cost centers. And it's what we are trying to achieve in a number of the projects. So if I may share from my experience, that's also the one of the solutions that we try to implement, but obviously always depend upon the business relations here. So even if I have the best clause written, if I have the best arbitration clauses, if I have the best arbitrators and best attorneys on my end, still it's all about the business relations here. So especially in this pandemic time, I see that it's, I would say, really very good time to also change your partnership, because we already noticed in a number of the countries when you can prove with which partners you want to continue the business in the long-term perspective, and which were the just short-term, I would say, very, one-sided oriented relations. So that's also a very good time to verify your friends.
Right. Well, does any other speaker have any perspective on that?
Yeah, sure. I mean, I think just picking up on Yaroslav's point, certainly from a legal perspective on the IT side, what we've seen with respect to this issue around sort of supply chain management has been, you know, that opportunity to try and get a win-win. You know, if you're dealing with a project that has sort of multiple sprints, multiple phases, you know, it may be the case that due to supply chain issues, and people always think about this as material as well, but it's also people. You know, one of the big things about COVID is the fact that a lot of very important individuals on projects or wherever it may be have actually been stranded in various places. You know, a great example at the minute is the level of different lockdowns that have happened across Europe and across, you know, the Middle East as well. So there's been individuals who have been key to projects that have actually been lost in, you know, in transition, as it were. They've potentially gone home at a particular time and can't get back, or they're in a particular region. For example, in the Middle East at the moment, Abu Dhabi, the capital of the UAE, is actually on a full lockdown. You can't get in or out of Abu Dhabi. So, you know, government projects that are happening there are people who are stuck outside that can't step in and actually work on those projects. And I think that, you know, that's certainly very pertinent from the construction side, but also on the tech side as well. So it's been a case of, you know, one of the negotiating points that we're trying to look and help both suppliers and customers with is, you know, can we sort of order the timeline and various milestones and start achieving things that are potentially standalone based on, you know, what we have in terms of both people and material. You know, when you're doing a sort of an automated or a cloud-based project, there are a lot of things that you can be pressing forward with, particularly on the testing phase, that don't necessarily need, you know, that supply chain issue. Now, obviously, if you've got hardware components, or you've got, you know, physical installation at premises, then you're also having to look at new regimes around getting people in, getting the right people in, finding the people that you need and moving those forward. But Yaroslav's point is absolutely right. There are ways that you can rearrange this on a win-win situation. And then, I mean, obviously the Middle East has has a lot of unique challenges in that the majority of you know, both tech equipment and even food is imported. So at times like this, you also need, you know, as Yaroslav said, you also need to know who your friends are, but you also actually need some help from the state. And I think one of the things the Middle East has done very well is they've continued to sort of use a lot of the grounded planes that would normally take individuals to actually bring in, you know, materials, supplies, and various other things, so projects can actually keep moving forwards. So it also helps to have friends in high places for certain projects as well, to try and keep supply chains moving. And when you're a supplier on a government project and you can ask the government for help getting in, you know, particular kit and particular individuals, I think that's been very, very helpful. So it really becomes a relationship piece around how you manage getting what you need where, and also, having a really grown up, non-litigant based conversation with your customer to say, this is what we can achieve in the current environment, and we can, as Yaroslav rightly says, I like the phrase that he used, keep moving things forward. There are things that you can keep moving despite the supply chain issues. And I think this has posed unique challenges for everybody, and it'll be something that people look at going forwards when you're designing a project. Project timelines will all of a sudden have to look at, option A and option B. Do we have an option A? Do we have an option B if something goes wrong? There's no point just saying force majeure anymore. We actually need to look at the reality that something really could shut this down. So I think it's been a real eye-opener in terms of, maintaining both a supply chain and the ability to have different options to drive a project forward in the event that something happens. It's the first time it's really been tested, and it's going to be a unique challenge for all of us going forward as to how we set up projects and contracts so there's multiple options and things can always keep going forwards.
Great. Thank you so much to all the speakers. One last question that's like one of the most intriguing ones. How are we using AI-enabled contract management for force majeure during this crisis? We can start with Ned, and can I ask all the speakers to give their perspective on this?
Yeah, sure. Thanks. And I did touch on some of this earlier, but yeah, I would say, again, it's just a situation where folks have to get through these contracts quickly, and it can be a whole host of different types of agreements. But they have to understand what the force majeure provision says, to Shaun's point, because they can vary significantly, and then understand the outside implications and how those tie into the force majeure analysis as well. So what we've seen is a manual review would be really time consuming, sometimes very expensive. So bringing in some AI to help with that heavy lifting can certainly accelerate the process, make it more cost effective, and then also more accurate. And I think from an accuracy perspective, and this kind of ties into that automation question earlier, it's not so much when you're thinking about that kind of the human against the machine, but really that attorney using the software against an attorney without the software. And I remember when I was practicing law as a junior associate and up at 2 in the morning, much like tonight in New York time, but going through contracts, and it was easy for things to fall through the cracks. So the software can certainly help with that and prevent that from happening. So again, it's kind of that symbiotic relationship between the human and the machine.
Step in while we wait for Shaun. Yeah, so sure. I love Ned's reminiscing about dark rooms and late nights and flicking through contracts. I think all of us as lawyers have been there. And I think, one of the great things about legal tech is this concept that all of a sudden, that type of drudge work can be taken away and automated, with the added advantage that it provides a huge level of accuracy as opposed to a tired, sleep-deprived junior lawyer in a darkened room. And I think this crisis actually has started to wake law firms up, particularly the big law firms up, to how important the deployment of this type of technology is, because in a time of crisis, your clients need a fast reaction. They need a quick reaction force in order to help them determine, what needs to be done, and how various things need to happen. And, a quick review of a force majeure provision, and Ned touched on it earlier, and I made the point as well. When you've got, a team of, potentially 5 or 6 different projects on the go with, 10, 15 different contracts and subcontracts and all the rest of it, and a crisis situation to manage, we do not have the time. And in fact, we didn't have the available personnel from a law firm perspective, because everybody's self-isolating and all the rest of it, to get a coordinated response together to get through this type of documentation. So, there's certain teams within our firm use AI, particularly on the litigation side, and Shaun may have an opinion on that. But I think this is really starting to highlight how valuable these tools are in terms of both, efficiency of response and the fact that they can be moving and working, whilst everybody else is either, isolated or in different places. And I think as we move towards more and more remote working, particularly in the legal field, then the deployment of AI and contract automation tools and review tools is just going to be more and more valuable. And I think the ability to sell those tools to clients in-house, like Yaroslav, who need help with this type of thing, you know, as part of a package of what we sell as part of our legal service, is going to be absolutely key. So I think it's really a case that this crisis is probably going to move on and accelerate the deployment of legal tech for these types of issues, because it highlights how important speed and accuracy is in a crisis. And as Ned rightly said, you know, if you're the attorney without that and you're taking 4 or 5 days, and you're the attorney with those tools and you're taking 4 or 5 hours, then there's obviously only going to be one winner and one survivor coming through this. So I think you know, as much as all of the negatives have been around this, I think it's been a real eye-opener to highlight the fact that legal tech going forward is going to be a vital component in any successful law firm, and for a lot of successful legal teams working in-house as well.
So the first question that we have got is from Ms. Ikra Musadak. She has asked, I would like to know your views on how your teams are managing paperwork and contracts that cannot be executed electronically. In many jurisdictions, certain agreements cannot be executed electronically. So do some or all of you face that issue?
Yeah, there's and of course we face depending on jurisdiction, some of the digital signatures are not recognized as our certificates for the digital signing. In a few, I would say, smaller countries in Southeast Asia have not been yet that developed, I would say, legal landscape that would allow us to use the digital signatures. So obviously we face the same issues everywhere, but you know, so I can just share the pain. I have the same issue as you do, and unfortunately, there's no good solution. You know, like unfortunately, especially in this less developed legal jurisdictions, we face the same issue, and there's no good solution. Just you know, just deliver. Yeah. Yes, still you need to preserve, you know, in order to preserve your entitlements, especially like maybe it was not said, the formal aspect of also preserving the entitlements, that's very important. That's how you can also be time barred because you haven't looked at the proper notices, or how in which form the notices should be submitted, etc. So that's also the thing that many or some of the, I would say, projects can really like fall down just because of this tiny small also formal aspects. So I would just definitely pay attention not just to the clause itself, but also how the notices should be submitted, in which form, especially for us in Singapore right now. If you want to benefit from the temporary measures act, you need to follow the notification template from the government that must be also submitting in the due time. So I would say that's very tricky time also in terms of where time is of essence for the notifications. So that's why all of the tools that can just accelerate the review process is critical, because here we talk about disruption that has global scale. So it's not just one country that is affected. We talk about, I would say, cross-border things that notification must be sent almost on overnight to each and every, I would say, of our stakeholders or business partners. So that's why also I would say any type of the measure that can really accelerate to the process of smoothing that, it would be very much appreciated from the business, definitely. Yeah? But as it comes to signing, we share the same pain.
Right, Robert, do you have? So yes, Ned, do you have any perspective on this?
Yeah, just kind of a quick comment. So I will say that about 80% of the documents that are processed by Brevia are scanned images. So they're not text searchable, and they're typically documents that are, you know, signed with pen and ink and then scanned in. One thing that's kind of interesting about that is the AI and the OCR software, which converts the scanned image to text for the AI to analyze, actually complement each other pretty well. So if you think about, you know, maybe a poor quality scan that would be difficult for the human eye to read, and that initial A in the word assignment maybe is converted as an O by the OCR software, the optical character recognition software, a keyword search would miss that. But because artificial intelligence is taking into account a whole host of different parameters, different fields, etc., it's still able to pull out the applicable concepts. So that's one thing that has resonated with our clients that are dealing with a lot of poor quality scanned images.
Right. Robert, if you can also let your perspective on this.
Yeah, sure. I mean, the question's a really good one, and you know, very similar to what sort of Yaroslav said, is that, as you can imagine, in the Middle East as well, similar to sort of Southeast Asia, there are a lot of contracts whereby sort of an electronic signature is just not a viable option. You know, and you know, we've been pushing, I think all of us here, both, you know, lawyers and people within industry, have been pushing to try and move sort of the boundaries on what and when an electronic signature can be used across a whole host of different contracts and contractual facilities. But there are still areas where, you know, the courts in this region particularly require a wet signature. So, you know, what we've tried to do and what we've tried to help clients with have been sort of, you know, halfway houses in terms of, you know, an agreed MOU, that an actual contract in this space will be signed on a specific date, and try to give people comfort that way. But no, I mean, very, very similar comment to Yaroslav. It has been a very difficult situation where, you know, you're asking clients to commit large sums or potential investments on something that really will only be recognised with a wet signature. So again, you know, trying to put a positive message on all of this, and I think there are a lot of positives to come out of this. I think it has moved the debate on the importance of electronic signatures forward. You know, if we are going to start moving towards a lot more in relation to remote working, we have to move towards a lot more and better tools for actually ensuring that a contract can be signed electronically, date stamped, time stamped. And as Ned rightly says, you know, we have the tools and the analysis now that can really ensure that this is recorded properly and is reviewed properly. And then another one of the big things that we're looking at in the Middle East is the use of blockchain for real estate transactions in particular, because real estate transactions traditionally have been very, very wet signature based, which takes a lot of time. And obviously one of the markets that is really going to be affected by COVID is obviously real estate. So there's a real move by the land departments in the UAE and Dubai in particular, which is great, to start to be able to execute, you know, real estate transactions using, you know, blockchain, and having those, you know, executions stored and properly recorded on a public blockchain controlled by the land department. So you can actually move real estate, you know, using an open blockchain with a very clear verification and record process. So it could well be that, you know, COVID-19, similar to the use of legal tech, starts to accelerate, you know, more and more innovative ways of actually providing agreement to a contract. That might make Shaun's job a little bit more difficult as a litigator, and I'm sure some litigators here are having nightmares about, you know, has a blockchain been hacked or has it been properly recorded? But, you know, I veer on the positive side of using innovation to try and drive things forward. And I think this crisis has highlighted that, you know, where wet signature is the only option, that's possibly not going to work. And it may well be that we have to start looking at new and innovative tools to try and, as we say, keep business moving and help everybody out.
Sorry for that. So we just have time for like one or two more questions. I'll quickly take things forward. The next question is by Deborah Fu. She has asked, has anyone seen a new contract being negotiated with new force majeure clauses, specifically providing that the ongoing pandemic can continue to be a force majeure event in the future, even though it is no longer an unforeseen event? Robert,
of course.
Yeah. Right. Jaroslav, we can start with you. Sure.
No, we can start with Robert. But I can just say on the business side, of course, you must. It must have been done since February. So since February, all of our contracts, they have obligatory, we drafted obligatory COVID clause. I even don't call it force majeure, because force majeure, as we said, allows you for the schedule relief. And we don't want just a schedule relief. We at least want to be invited to the table to discuss further consequences. Yeah. So to allow the double, I would say, relief also on the cost side. So I cannot imagine right now in my business signing the contract, big, large-scale contracts without the properly scheduled COVID clause that would allow me also for the price relief. Robert, ball to you.
Yeah, no, I mean, Yeah, no, absolutely the same point. I mean, it is a you know, the critical point now that we have, as Jaroslav rightly said, almost a unique and individual COVID-19 clause to state that, you know, if there is a rebound, if there is a second wave, the fact that different countries are coming out of this at different speeds, you know, we have to have specific provisions to enable us, you know, if this crisis accelerates or returns, to negotiate certain components. You know, the concept of it's being seen or unforeseen is a bit of a misnomer, because, you know, we can't foresee, you know, we know it's there, we just don't know what's going to happen with it next. I mean, Beijing's now gone on to a lockdown. There could be a wider lockdown enforced again. So all of this is very, very conditional, and all of the relief work orders, the change orders that we're doing are all based on, you know, a specific set of events. And there is a COVID-19 clause in there specifically that states, you know, if countries go into lockdown, if we have supply chain issues as a result of, you know, a further occurrence of COVID-19 or a related pandemic or whatever it may be, you know, these are the circumstances, these are the discussions we will have. So it's all very sort of conditional on certain things happening, on a certain status quo. You know, the idea of a new normal is still very up in the air. So yeah, it's absolutely vital that you have, as Jaroslav said, a COVID-19 clause that specifies that this is how we see this moving forwards. But if circumstances change, particularly influenced by either COVID-19 or governmental action or some sort of event, whether foreseen or unforeseen, then there are options within the contract to change timelines, get relief, and have a further discussion about how we continue to move the project forward. I think anybody negotiating a contract without those provisions is hugely negligent, because, you know, it is likely to be with us for some time. And not only that, but, you know, the different ways governments are going to handle the post-COVID-19 world may also affect things. There may be some, you know, restrictions on what can and can't be exported or imported. There may be restrictions on which suppliers you can use. You know, there may be people saying that you have to have a certain percentage of a particular project run by a subcontractor based in a particular territory. There may be changes in applicable laws as a result of all of this, which may, you know, inflate the cost of a particular project for the supplier or for the customer. So all of this needs to be built into taking these contracts forward. It's not just a simple case of, okay, we're fine, we've got a force majeure event and we know COVID-19 might not occur again. There are a lot of other sort of elements to this that we have to guard against to make sure that, you know, we agree, you know, plan B. But then if plan B blows up again in 2 months, we're straight back to the start and we have to renegotiate all of this. So yes, lots of parameters, lots of conditions, lots of components put in place. And yes, as Jaroslav says, a very specific COVID-19 clause that allows us to sit down again and agree certain other components based on the impact that a second wave or anything that the government does around this.
To thank all the speakers, Jaroslav, Ned, Shaun, and Robert. Thank you for joining us. It was amazing to be your host. I think we covered some really powerful points, and the delegates, I'm sure, will have some very, very interesting things to share as feedback. I'm sure, you know, we'll be sending them a feedback form. So, you know, and if anybody has questions offline, we'll be connecting you directly with them. And thank you so much. There are, you know, what you see on your screens at the moment are our global event sponsors. You know, we won't be able to organize events without them. And thank you so much for all our sponsors. And if you have any questions, you can always write us at info@eventsforshow.com, and we'll be very happy to answer them. As a matter of fact, if you have questions regarding this particular webinar, you just have to simply write us on info@eventsforshow.com with a question and the speaker you would like to, you know, to point that question to. And also, please visit www.eventsforshow.com to know the latest of all the events that we're organizing across the globe. You know, thousands of senior legal professionals are joining us for the events, and it'll be great to be your host at those events. So do register for our events. Thank you so much, and have a wonderful day, everybody.
Thank you a lot.
Thank you very much. Take care.
Ciao.
Thank you.
Thank you, everybody.